Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Sign there. Your Honor, subject to the court's approval in 22 CC 2025 CR 210, the defendant, Mr. Cord Cameron, will enter a no contest plea to the DUI fourth offense, which is charged by information. He signed the waiver of indictment, and he is signing the plea of guilty, or excuse me, the plea of no contest, Your Honor. On this, his punishment will be 4 years to serve with TDOC at range 3, 45% release eligibility. He has a $3,000 fine and costs, and he has a loss of license for 8 years. And this will run concurrent to a General Sessions case, GS 22 CR 1127, as well as concurrent to a Davidson County case 2021 A 432. There were other charges that are in bind over, but these are being nullied, again, subject to the court's approval through a separate order. And beyond that, I've discussed the DUI enhancements with the defendant. He understands those and is signing the notice of DUI punishment. I believe that concludes it, Your Honor. I'm handing up this paperwork. Thank you.
All right, Mr. Cameron, raise your right hand. Let's place you on the oath. Mr. Cameron, if you'll state you can put your hand down, but state your full name for the record.
Cord James Cameron.
Mr. Cameron, I'm going to go through your rights regarding these issues, and I just need you to make sure that you understand them and that you make a verbal response so we can record everything that's being said, all right? Do you understand, first of all, that you are charged here, or you're not charged, but you're proceeding today under what we call a criminal information. Every person who is charged with a criminal offense that carries the possibility of incarceration has the right to have their case reviewed by the grand jury of the county in which it occurred. The grand jury is an independent body that reviews the evidence. They only hear one side, but they determine whether there is sufficient probable cause to even return an indictment. And if they do, then it comes to the circuit court. To expedite the disposition of your case, you can waive the grand jury's presentation of that case or their consideration of that case and proceed on what's called a criminal information, which is what we're doing today. But do you understand that you're waiving your right to have the grand jury review this case?
Yes, sir.
Do you also understand that what you're charged with and that this case, as Mr. Talbot has explained, is going to resolve several different things. Some other charges that are making their way up through the system are going to be dismissed, and you're going to be entering a plea to serve some time in prison. You understand that?
Yes, sir.
Do you understand everything you're charged with? Do you understand the nature of this charge? And have you talked it over with Mr. Talbot? You and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
While it's indicated that you want to enter a plea, is this a plea of no contest? Yes, a plea of no contest. That means you understand what the facts are going to be. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And they're going to tell me what their evidence would be at trial, and it's that evidence that I will use to support a finding of guilt in your case. Do you understand that?
Yes, sir.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court.
Yes, sir.
You understand you would have the right to have a lawyer at trial and to have one appointed if you cannot afford one, and we've already done that with the public defender.
Yes, sir.
Do you understand at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of any crime?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Talbot could confront and cross-examine every witness the state might call to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, or no contest, rather, by pleading no contest, you're waiving your right to contest the guilt or innocence, and you're waiving your right to a trial and to an appeal. And all I'm going to do is approve what your lawyers worked out.
Oh, yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you understand that's going to result in a felony conviction? But that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
And it's been explained to me that your lawyer has gone over with you what we call the DUI enhancement provisions of the law, which is that every conviction results in a larger, more harsh punishment the next go-round. You understand that?
Yes, sir.
You understand everything I've explained to you thus far?
Yes, sir.
You want to plead no contest and waive your right to a trial as I explained.
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No.
You understand that I can't accept your plea unless I'm satisfied that you are in fact guilty and that there are facts to support it.
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, if this would go to trial, the state would show them on or about June 30th, 2025. Officer Morrison.
All right, Mr. Cameron, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Talbot's done a good job of representing you competently?
Sir.
All right, Mr. Talbot, do you know of any reason you should not enter this plea?
No, sir.
Anything further from the state? Then Corey J. Cameron, and docket number 2025 CR 210, upon your plea of no contest to count one, I find that you are in fact guilty, sentence you to 4 years in the Tennessee Department of Corrections to serve as a range 3 offender. You're ordered to pay a $3,000 fine. It costs your license to drive is suspended for 8 years. This sentence will be concurrent to your general sessions violation of probation, as well as your Davidson County violation of probation. And the remaining, there are other cases that are being nollied as a result of that plea, and I have signed that order to dismiss those other cases. All right, thank you.
Thank you, Your Honor.